What happens when an AI tool can conjure a famous superhero with one prompt, and the studio that owns that hero sues? A major studio just sued a popular AI image platform. The complaint claims the service began producing images that look unmistakably like iconic characters. The studio says those outputs traded on decades of design work without permission. This lawsuit landed in a Los Angeles federal court and pushed a thorny question into the spotlight. When does an AI output cross the line from inspiration into unauthorized copying? Here's what the complaint actually alleges and why it matters. Why should creators care? The lawsuit targets two legal fault lines: models trained on copyrighted material and outputs that look substantially similar to protected designs. Win or lose, the decision could force platforms to change prompts, filters, or licensing. Millions of artists and marketers generate images with these tools daily. A legal precedent here would ripple into how we prompt, sell, and share visual work. The stakes are both creative and commercial. So what exactly is at stake next? This isn't an isolated fight. Other lawsuits have already named AI firms for training on copyrighted images and reproducing artist styles. Getty and news organizations have sued over alleged unauthorized training. Musicians and labels are suing audio generators for replicated vocals. The pattern is consistent: rights holders testing theories in court. Hollywood joining this wave was predictable. But each case adds a slightly different legal puzzle piece, and the Midjourney dispute could be a keystone. Next, what does the studio actually claim? The studio alleges the platform generated visuals closely mirroring protected characters and then loosened safety filters, presenting that change as an upgrade. That relaxation reportedly made it easier for users to produce near-identical images. The complaint also claims the platform profited from engagement driven by recognizable properties. The studio is seeking damages, disgorgement of profits, and injunctions to stop unlicensed outputs. These are allegations, but they echo claims from other high-profile suits and raise tough legal questions. At the heart of the dispute are two questions courts keep circling. First, can an AI lawfully train on copyrighted content without permission? Second, even if training is allowed, when is an AI-generated image too similar to a protected work? Answers could redefine whether training counts as transformative research or unlicensed copying. Lawyers will parse precedents and recent Supreme Court guidance. But first, we need to understand how these models actually produce images and why that matters for similarity. Technically, the platform at issue uses diffusion models. These systems learn statistical patterns from massive image-text datasets and then sample new variations to match user prompts. They don't copy-paste pixels. They generate outputs from learned distributions. Still, statistical learning can internalize distinctive features. If a dataset is heavy on a specific character's imagery, the model can recreate recognizable traits. That possibility turns a technical architecture into a legal risk. So how do courts evaluate that risk? Legal rules are unsettled. The U.S. Copyright Office says fully AI-authored works can't be registered, and courts now demand a stricter test for transformative use after a recent Supreme Court decision. That ruling narrowed how courts view commercial transformations. Older cases allowed some large-scale scanning for search and indexing, but image synthesis is different. Judges will weigh purpose, similarity, and market substitution, so the outcome may hinge on whether the new image acts as a market substitute for licensed art. Characters like the ones at issue carry layered protection. They're not merely drawings. They're copyrighted designs, trademarked symbols, and licensed likenesses tied to merchandise and media deals. Reproducing a distinctive shield, emblem, or silhouette can trigger multiple claims beyond copyright. Think trademarks and unfair competition. That means courts examine more than line work. They consider overall recognition and brand value. So the law treats iconic characters differently from a single photograph or a generic model. How does a generated image cross the recognition threshold? Two things amplify the risk. First, trading datasets dominated by specific IP amplify distinctive features. Second, weak filters let users prompt for named characters or close descriptions. If the average viewer identifies the character, courts may see it as trading on protected expression. Recognition matters more than whether the model literally copied pixels. That recognition standard is why safety settings and prompt rules are so consequential. Platforms deploy guardrails to reduce harms. These include prompt filters, content moderation, and blacklists for trademarked names or logos. The complaint alleges the company dialed back those controls, making infringing outputs easier. That raises potential contributory or vicarious liability. If a platform knowingly enables infringement and profits from it, rights holders argue the platform shares blame. Courts will probe whether the company acted recklessly or simply provided a neutral tool. The distinction could decide liability exposure. If the studio wins key motions, expect swift changes. Platforms might block named characters, add style filters, or create licensing marketplaces for branded assets. Companies could log prompts and outputs to comply with takedowns and respond to owners. That would insert more friction into creative workflows and push users toward paid, license-backed options. The creative Wild West would contract around managed, brand-safe modes. But how likely is that outcome, and what would a defense victory look like? If the platform prevails or courts set a narrow test for similarity, the opposite happens: broader leeway for emulation. Training on copyrighted works might be treated as permissible learning in some contexts. Courts could require more concrete proof that outputs substitute for licensed works. That would preserve creative fluidity and let users keep experimenting with adjacent styles. But protection wouldn't vanish. Trademark law and specific logo reproduction would still constrain behavior, and platforms would still face reputational pressure. If the platform prevails or courts set a narrow test for similarity, the opposite happens: broader leeway for emulation. Training on copyrighted works might be treated as permissible learning in some contexts. Courts could require more concrete proof that outputs substitute for licensed works. That would preserve creative fluidity and let users keep experimenting with adjacent styles. But protection wouldn't vanish. Trademark law and specific logo reproduction would still constrain behavior, and platforms would still face reputational pressure. So where does that leave creators? Practical steps help manage risk. Avoid prompts that name protected characters, lean into original silhouettes and color palettes, and treat AI outputs as drafts rather than finished assets. Keep records of your human edits and creative input. If you plan to commercialize images, consider licensing or ask permission. These habits protect you from legal surprise and keep your brand safe. Next, what should studios and brands do differently? Brands and studios can turn risk into product. Licensing marketplaces, brand-safe packs, and watermarking can monetize fan creativity while protecting IP. Investing in detection tools, logo recognition, and watermark scanners helps enforce rights at scale. Trade groups can align standards so companies don't play whack-a-mole. In short, control plus access equals new revenue models. For AI developers, the commercial demand will shape technical priorities. Let's look at those developer fixes next. AI teams need better permissions layers, stronger default filters, and enterprise modes with indemnities. Offer IP owners ways to claim and constrain assets. Add auditing trails that log prompt output pairs for compliance. Build paid branded packs that guarantee clearance. Those engineering and policy choices reduce litigation risk and create enterprise revenue. For regular users, the platform's defaults will shape what you can prompt. So what practical rules should everyday users follow now? Everyday users, keep it simple. Don't prompt for named characters or distinctive logos if you plan to post publicly. Use AI for sketches and iterate into original designs. Favor public domain references or licensed assets on reference boards. If you used AI, disclose that in your posts. Transparency builds trust. And if you want to sell artwork, favor commissioned or licensed channels. These are practical habits to avoid legal headaches and keep your creative momentum. Next, a brief legal primer to decode the jargon. Quick legal primer. Fair use is a flexible test courts apply case by case. Substantial similarity looks at total concept and feel. Trademark law protects confusingly similar marks and trade dress. And DMCA 1202 prohibits removing or altering copyright management information. Recent court rulings tightened the transformative test, especially in commercial contexts. These doctrines intersect here, and judges will weigh them together. How courts balance these factors will drive the practical impact of this case. Licensing often resolves conflict. Think Music's Content ID, stock photo deal structures, and paid font licenses. Platforms could offer IP-safe modes, pay for branded packs with clear permissions and watermarked outputs. That model shrinks gray areas and creates monetization channels. Expect platforms to test tiered access and enterprise indemnities. This won't be as spontaneous as the early days, but it creates sustainability. Next, practical prompts and habits you can use immediately to stay safe. Prompt tips: ask for vibes, not brands. Swap famous hero language for vintage pulp hero with bold colors. Avoid logos, shields, and distinctive emblems. Change silhouettes, chest icons, and facial features. Use public domain or licensed reference material. Credit AI contributions when you post. Document your human edits. Those habits turn AI from a legal liability into a creative partner. Now, what should viewers track as this case progresses? What to watch next? Early rulings on preliminary injunctions will reveal how judges see immediate harm. Platform updates could show how vendors balance risk and growth. Industry coalitions might set common standards. And regulators or the Copyright Office could issue new guidance. Any of these moves will accelerate changes in tooling and behavior. Keep an eye on court filings and major platform policy updates. Time for a quick mid-video recap before rapid-fire answers to common questions. Mid-video recap: a studio sued an AI image platform for producing lookalike characters. The case raises two big questions: training legality and substantial similarity of outputs. Outcomes could force filters, licensing packs, or broader creative leeway. Creators should avoid named prompts, document edits, and favor original designs. Platforms will likely strengthen guardrails or offer paid clearance. Now onto a rapid-fire FAQ to clear the most common uncertainties creators ask. FAQ snapshot: is generating a protected character legal? Personal experimentation is lower risk. Distribution or sale is risky. Can AI companies train on copyrighted images? The law is unsettled. Will changing colors be enough? Often not. Courts look at overall recognition. Could platforms block branded prompts? Yes, and many already do. Will this kill AI creativity? Unlikely. Expect adaptation through licensing, filters, and new workflows. Those quick answers set expectations while the case unfolds. Final takeaway: this lawsuit accelerates a rule-making moment. It forces platforms, studios, and creators to negotiate practical guardrails around powerful tools. Expect more filters, clearer licensing paths, and stronger auditing. Creativity won't vanish. It will evolve around legal and commercial realities. When a prompt can conjure a beloved hero, law steps in to define the boundaries. This case won't be the last word, but it will shape the next chapter in AI creativity. And that's just the beginning. If this breakdown helped, please like and subscribe for weekly explainers. Comment with one question you want answered next about AI and copyright.